This is the interesting case of the Huron County Witch Trial, or to use its correct legal name, the case of Rex v. Pollock. It is the story of Maggie Pollock, a woman from a small community in Ontario, Canada, in the early part of the 20th century. It revolves around how she used allegedly supernatural skills to find missing and stolen property for people, and how those services she offered ended up seeing her prosecuted under the Criminal Code of Canada for a witchcraft-related offence. The case was decided in the Appellate Division of the Ontario Supreme Court in 1920, but the events of the story began unfolding years earlier. In 1919, Margaret Pollock, better known as Maggie Pollock, was a woman of 40 years who resided on a farm in Morris Township in the province of Ontario. She made a living working on the farm, which was owned by her brother, but also earned income from providing services of a rather unusual nature to the inhabitants of the region. You see, from an early age, Miss Pollock began to delve into the world of the supernatural. She stated she would receive visions and communications from the spirit world. With the assistance of these spirits, she would offer to help the people of Morris Township to locate items that were stolen or lost, and in return they would show their gratitude by paying her a small sum of money. As of 1919, it is reported that the average payment was 50 cents, which would work out to approximately 8 Canadian dollars in 2024. Now, offering services of this kind was controversial. Many considered communication with spirits to be unwholesome or even sinful, but Miss Pollock asserted that it was a completely natural God-given gift, and she did not believe there was anything untoward about it. Indeed, she told people she felt compelled to use the gifts she had been given to help others. Regardless of the origin of her talent, in the year 1919, Miss Pollock was approached by a man named John Leonhardt, who was in search of some oats. He believed that a person or persons unknown had stolen the oats from his barn, and he sought out Miss Pollock so she might exercise her powers to find them. After holding one of the man's mitts in her hand for a time, Miss Pollock announced that the spirits had shown her a vision of the oat theft, and proceeded to give him a description of the thieves and the direction they had fled with their ill-gotten goods. Mr. Leonhardt then paid Miss Pollock the customary 50 cents and went on his way. The historical records I could locate did not reveal what happened to Mr. Leonhardt or his search for his stolen oats after this, or whether the information that Miss Pollock provided was of any help to him. Whatever may have become of the oats, it appears that someone reported Miss Pollock to the authorities, for later that year she ended up being prosecuted for committing a crime against Section 443 of the Criminal Code, as it was then written, which proclaimed as follows, quote, "Everyone is guilty of an indictable offense and liable to imprisonment for 1 year who pretends to exercise or use any kind of witchcraft, sorcery, enchantment, or conjuration, or undertakes to tell fortunes, or pretends from his skill or knowledge in any occult or crafty science to discover where or in what manner any goods or chattels supposed to have been stolen or lost may be found." End quote. Brought to trial in the county court before Judge Henry Dickinson, Miss Pollock argued for her innocence. A Mrs. Grace Sinclair also testified on Miss Pollock's behalf, attesting to how Miss Pollock was not fraudulent and recounting how Miss Pollock had previously helped her find a lost gold ring using her supernatural gifts. However, this did not sway Judge Dickinson, who convicted Miss Pollock of pretending to use occult knowledge to discover the whereabouts of stolen property, contrary to Section 443. Although the judge did agree to suspend the passing of sentence to allow her to go free while her lawyer appealed the conviction to a higher court. In March 1920, the appeal was taken up in the Ontario Supreme Court, sitting in the historic Osgoode Hall in Toronto. On appeal, the lawyer representing Miss Pollock advanced several arguments in her defense. To start, he pointed out that many prominent persons of the day also believed in the spirit world and mentioned some by name, such as Sir Arthur Conan Doyle, the famous author of the Sherlock Holmes novels and also an enthusiastic proponent of spiritualism. He questioned whether it could really be intended for the law to prohibit occult practices when such upstanding citizens also engaged in similar behavior. The defense further argued that since Miss Pollock honestly believed in her ability to commune with the spirits to gain insights on the whereabouts of lost or stolen property, that she did not have the necessary dishonest mind required for conviction. After all, this section talked about pretending to practice witchcraft, and it was obviously aimed at dishonest and deceptive conduct, not the actions of honest citizens who were not seeking to cheat anyone. Unfortunately for Miss Pollock, when Justice Ord handed down the decision of the Ontario Supreme Court, the defense arguments did not prevail. On the point that other persons also engaged in spiritualism, the justice pointed out that the law did not prohibit people from engaging in seances or other supernatural pursuits in general, only in certain specific ones, such as finding stolen or missing property. Additionally, the justice ruled that a person could be guilty of pretending to practice prohibited occult arts specified in the law, even if the person honestly believed they had such powers and had no intention to cheat anyone. For one thing, Justice Ord noted that the word pretend in Section 443 was being used in an older sense of the word, which roughly equated to profess or claim, rather than being deliberately dishonest. For another, the justice declared the court needed to look to the intentions of the lawmakers when interpreting the law, and in the eyes of the legislators, supernatural powers were not a reality. It was the lawmakers' intent to criminalize the act of claiming to be able to supernaturally locate property because they presumed to be impossible and false, regardless of whether the person who made the claim knew it was false or not. To put it another way, such occult practitioners were guilty of pretending to practice the occult even if they didn't know they were pretending. According to news reports from the time, after the Ontario Supreme Court upheld her conviction, Miss Pollock did not receive any prison time. Instead, she received a $200 fine, about $3,000 in 2024 dollars, and was admonished to cease her occult property location services. Although, to be clear, she could still legally give opinions on where property might be found, just without making mention of any supernatural sources of knowledge. Interestingly, laws against pretending to practice occult arts, including a law against fortune telling, would remain on the books in Canada in some shape or form for another century. It wasn't until 2018 that Section 365 of the Criminal Code, which was the more modern equivalent of Section 443, was repealed. Even more interestingly, a woman had been charged with violating that section only a few days before it was repealed in 2018. But that story will have to wait for another time, possibly. So, what are the closing thoughts about this case? I suppose it shows that there is a long history of fear for those who practice arts that are seen as occult, and until recently, the law was used to suppress these activities. Gradually, over the centuries, the penalties became less severe, being downgraded from the death penalty that was common in centuries past to a mere fine in the case of Miss Pollock, but the fear and distrust remained. Perhaps now we are beginning to move past such fears. One can only hope.